Drinking and driving cases in Virginia are fairly serious events. They can result in a conviction, which can lead to losses of license, as well as jail time. There's a number of things to expect when you've been pulled over. The first to understand is there's a few different reasons why a person may be pulled over. First may be driving behavior, speeding, swerving, not staying within the lanes, illegal types of turns and stops. Additionally, people can be questioned as to whether they've been drinking and driving at the scene of an accident, once an accident has happened. It's important to remember that regardless of whose at fault that accident is, the questions from the police can still be asked about whether or not drinking was a factor. A number of the things that you can expect to be asked are when did the last drink occur, as well as how much did the person have to drink, and whether or not they had been driving since the time of their last drink. Many times in an accident, the car is no longer running, and so one of the things the police have to determine is whether or not any of the alcohol that was consumed occurred after the accident occurred, after the vehicle was stopped. If there is a reason or a probable cause for the police to think that a person might be under the influence, a number of things will occur. The first is a series of field sobriety tests. What that means is a person may be asked to walk a line, may be asked to use letters of the alphabet, may be asked to test their eyesight to determine whether or not they appear to be under the influence. If there are enough positives in those findings, then it's likely that the person would be arrested under the suspicion of drinking and driving. An additional test that's given at the side of the road many times is called a PBT. Essentially, that's a preliminary breath test, and that's to test to see what the initial alcohol level is. Now, it's important to remember that that number is not admissible before a judge or a court, but it can be used by the police to determine whether or not there's a reason to believe that the person may be under the influence. If someone is believed to be under the influence, they can be arrested under that suspicion and brought to the police station, where a breath test and a more formal breath test can be administered. If the level comes out beyond a .08, then the likelihood is that there will be a presumption that the person was under the influence at the time that they were driving, and an arrest will be made. They will be brought to the jail. They will be held until a magistrate makes a decision of whether or not to release them on bond. And as well, they will be allowed to contact family members or other people to come and pick them up. Additionally, if you hold a Virginia driver's license, you can expect to have your driver's license administratively taken from you for 7 days. After that time, that driver's license will be returned to them, and they will be able to drive fully and completely as if there were no charges against them up until the time that the final court case occurs. It's important to note that a number of things can be done in preparation for that court case. The first thing is to determine whether or not there is a reason to have pulled the person over. For instance, it's not necessarily just enough to have somebody leave their line of travel for just a moment. There has to be repetitive techniques done and repetitive attitudes done in order for a person to be believed to be under the influence. Additionally, it is important for the police to be able to prove certain things about the driving behavior as well as the alcohol consumption of the defendant. And in any of those cases, if that's not met, we never reach the level of determining whether the person was under the influence because we determine that the police don't have the right to pull them over. The same can be said with the alcohol levels involved. The proper methodology has to be taken, the proper techniques have to be used, the proper certificates of analysis have to be filed. And if any of those things fail at any one or step in the process, then many good things can be done in order to alleviate any and mitigate any potential problems associated with a conviction. In order to fully explore those and in order to fully determine whether defenses exist, it's important that a defendant, as soon as possible, contact counsel in order for a consultation, an evaluation, and to make a determination as to what, if any, defenses they may have in these cases. The earlier that you get involved, and the earlier a defendant gets an attorney involved, the better the opportunity is to fully flesh out the defenses, to fully make sure that we mitigate any potential downside that an arrest such as this and a potential conviction such as this will have.